Instead of confusing motion for action and picking up where you had closed off, Mr. Rosenblood, and understanding that at this stage of this Parliament we're unlikely to affect legislative change, what would you see as important recommendations that could come out of this committee?
So I think there needs to be recognition of how the way Canadians communicate with each other have changed. And I think it is appropriate to take a look at a considered approach on how existing legislation might be amended to reflect that. Our concern is that we take a look at these alarming trends, and rather than take a well thought out approach that we feel that based on evidence and research is likely to have the greatest impact to mitigate these harms, we instead take a knee-jerk reaction, an instinctive approach that will most likely have little to no effect and could very possibly exacerbate the harms that we are attempting to reduce or eliminate.
Okay.
So,
thank you very much. Deacon Bennett, you had talked about bringing the spectrum of faith groups, for example, into the public square. Do you have any examples of where that's done elsewhere, or how that could be implemented, and how that conversation could be facilitated by government?
Well, I think it does happen currently. There are numerous examples across the country of where different communities come together. I mean, for example, I broadly agreed with what most of my colleagues next to me had to say, but we obviously share very different beliefs.
Right.
So government, I think, needs to ensure that people with very diverse views are able to engage in the public square and to have robust debate, recognizing that if that debate is carried out peacefully and in goodwill, you can have very deep disagreements. And so I think I would agree with my colleagues here that you have to have a broad scope for freedom of expression in the country. But there is definitely a red line where that goes into inciting violence, commensurate measurable harm against people. So I think there are obviously others that are going to comment on specific legislative changes, but I think government, in the interest of serving the people, have to ensure that all voices can be present in the public square and that you don't push voices to the side. Now, those that are inciting violence, that's a different story, and there are obviously appropriate punishments for that.
Okay, thank you. And Mr. Dennis.
Yes.
And what steps would you advocate for at this juncture in this Parliament, where we're unlikely to affect substantive legislative change? What recommendation should come out of this committee?
Well, I realize that you're at a tenuous place in your legislative process. What I would underscore, as my colleagues have said, is that there is a great health to a democratic system when people who have profoundly different views can do so publicly, can engage publicly, and that should be protected and respected, of course. The line is when does free speech end and when does hate begin? And in that sense, I think that in the moments when speech, as my case study tried to illustrate, can incite violence, is what needs to be legislated against. What you can do in the short time frame you have is of course perhaps beyond my expertise, but I would sort of fundamentally say that needs to be legislated in a broader sense.
Thank you very much.
Thank you, Mr. Barrett. Mr. Fraser.
Thanks, Mr. Chair. Thank you all to the witnesses for being here and giving your points of view on this. I'd like to start with Mr. Rosenblood and Mr. Oliver, if I could. Just can I understand the position of your organization then with regard to online speech or online content as it is now on Facebook, on other social media platforms? Do you think there's a problem?
Absolutely, there is. Sorry, I've lost my voice. In particular, like harassment, things like doxing and misinformation campaigns, These are sincerely real problems that we're facing.
What do you mean by doxing?
So that would be the revealing of personal information like addresses and phone numbers to the public against the intended targets of permission.
Do you think there are people, sir, do you think, sir, that there are minority groups who are specifically being targeted and treated unfairly on social media platforms?
Certainly, one of our own members was victim of this when he was promoting the idea of removing public prayers from his city council in Saskatchewan.
Do you think there is a role for government to play in combating what seems to be agreed upon as being a rise of, on social media platforms, of intolerance?
Yes, we do. We just urge caution. Any measures taken are done cautiously and judiciously, and there's no overreach.
And when we're dealing with let's say a young person, an impressionable young person who is using social media platforms and in their growing into an adult, informing themselves about different worldviews and about different religious philosophies and about different ways to interact with other individuals. Do you think there's a role for government to play in order to limit, to a certain extent, the ability for individuals who are trying to exploit impressionable young people into certain hateful ideologies? Do you think there's a role for government to play in order to try to curb that, or do you think it should be unlimited and up to
No.
we make those decisions for themselves?
We lean towards more of a civil libertarian position with respect to free speech, but we certainly acknowledge that there are limits, and this is a great debate to have. Where is that red line? And we don't object to government action when needed, if that's your question. And certainly there are a lot of ugly ideologies out there, and also. We're all, it's a brand new platform, the internet. There's all sorts of complexities to this issue that I think we're all grappling with.
Would you agree, though, like if a certain religion is being targeted, and I totally understand the point and agree with it, that you can attack a person's ideas, but you can't attack the individual's dignity and character of a person and their right to hold those different views. Do you see, though, that it can be a blurry area between calling into question a person's ideas and ideology and actually attacking the character and demonizing that individual?
Well, I mean, I would you like to comment on that specifically?
I think there is a world of difference between attacking an idea and attacking a person. One can attack Christianity without demonizing Christians. Similarly, or you can assert Judaism and Jews, or Islam and Muslims. One can take a look at the sacred scroll of your choice and say, this is why I believe this to be holy, or this is why I believe this text to be vile. This does not mean that people who follow the words of that text are necessarily more noble or inherently evil for having genuine beliefs about that scroll.
And demonizing individuals, you believe there's a role for government to play in combating that type of demonization?
The government already does have laws against demonization of individuals, whether it's through slander, libel, defamation, and so on. These are existing laws on the books, and we as the Secular Alliance do not object to the existence of these criminal these sections of the criminal code.
Demonizing an individual because of their beliefs, would you think that that's a problem?
Well, then it becomes a personal attack and not one on the ideas of the faith, if it's about the individual. And then you have to take a look at the specific context of what is being said. Saying, I do not like you, sir, is not hate speech. Calling for violence against you would be.
Do you think that these sort of attacks that can happen online to individuals based on their beliefs can lead some to perhaps see them as less than equal humans?
There's a lot of hypotheticals in there. I find it hard to draw a connection between an attack on a belief leading directly to demonization of an individual. If you are already directly attacking an individual, and it happens to be because of their faith, then it's the attack on the individual that matters, and not the criticism of the underlying faith.
Okay, if I...
You're out of time, Mr. Fraser,
that
so
went by fast.
thank you for
Okay.
that, Mr. Garrison.
Thank you very much, Mr. Chair. I want to start by addressing the defamatory attack on Representative Brian Sims, who represents the 182nd District in the Pennsylvania House. He has done so in a very distinguished manner for the last 7 years. He was the first openly gay man elected to the Pennsylvania legislature in 2012. He's won awards for his national and state work in advocating equality for the LGBT community, but also in his advocacy for the right for women to choose. He is sometimes a controversial figure, and he's described himself sometimes as unfortunately having the mouth of a truck driver. But he has attracted many attacks of the kind we witnessed here this morning. I think that Mr. Dennis is lucky that his remarks are protected by parliamentary privilege because they appear to be drawn from simply from a Fox News editorial of the last couple of days, which defame Mr. Sims by comparing him to a drug-addicted vagrant, by using other terms which I will not dignify by repeating. One of the times that I was most proud to call him a friend is when he read into the record in 2016 in Pennsylvania the names of each of the victims in the Pulse nightclub shooting, victims of a hate crime directed at a community. So I just wanted to put that on the record, since I was very disturbed by the remarks which Mr. Sims would have no chance to respond to. Turning from that to the very interesting question I think that Mr. Fraser just raised, I want to go back to Mr. Rosenblood. He was very careful to say that when ideas relate to individuals, that he accepts that there has to be a limit. In my community just last week, we had the rental of a public facility to a group and a speaker which attacks transgender people as threats to all women and threats to children. And so while in that speech that takes place, there's no identifying of individuals, it does promote hatred against a group. And so since you focused on individuals last time, I'd like to ask you whether you accept that there is a limit and that there should be criminal sanctions against promotion of hatred against a group and not just individuals. Either one.
Go ahead.
Okay. Yes, being able to, criminal sanctions should not simply be against identified named individuals. So, whereas saying that Leslie Rosenblood should be attacked because he's Leslie, it would also be equally an offense under the law, or should be, in our opinion, that all members of the Canadian Secular Alliance should be attacked, of which I happen to be one. So whether the group in question is one of voluntary membership, as in the Canadian Secular Alliance, one of religious affiliation of any sort, or as a member of, for example, the LGBT community, calling for attacks or violence against unspecified members of an identifiable group should be subject to criminal sanction to an equal extent as a named individual.
And so what about, and it's not a federal jurisdictional question, but about the use of public facilities for the promotion of hatred against groups. So do you believe that public entities, whether it's a municipality or even, say, the House of Commons, should have policies in place that would prevent the use of public facilities for promotion of hatred? So
there's a number of complexities in there. So if the public facility is open to the public or whether it's reserved for certain specific purposes would have a bearing. Assuming, for the sake of this discussion, it's open to the public, then there is no implied approval or endorsement of the ideology or background of whoever is renting the group by the government, simply because they're using they're using the facility by a municipal, provincial, or federal government. If there are illegal acts being conducted as a result of that, then these must be prosecuted accordingly. However, should you fall short of that and they are simply doing saying highly distasteful or objectionable goals, I do not think that the government should neither endorse nor condemn speech that's happening from people that rent those facilities. The government must remain neutral. Again, assuming that it's A, open to the public, and B, no criminal incitement is happening as a result of that transaction.
Well, in the case I'm referring to, it was pretty clear in the title of the speech that was submitted to the municipality that the purpose was to promote hatred against an identifiable group. And I have to say I was very pleased in my community that there were approximately 15 people attending the talk and approximately 300 people outside.
Garrison, you're out of time, so just wrap up.
I'll leave it there.
Garrison, Mr. Assassi.
Thank you, Mr. Chair. I'd like to thank all the witnesses for their testimony. Now, my first question would be for Mr. Rosenblood and Mr. Oliver. Having heard your testimony, I understand that you're saying that we should be amending existing legislation. I also understand that you're very much concerned about the overreach of the law. So that having been said, you actually delved into section 319(3)(b), and I was wondering, you, I understand, are in favor of repealing 319(3)(b). Do you think any such action would restrict freedom of religion?
Well, essentially, we don't. We strongly believe in freedom of religion, also freedom to hold no religion, of course. We think that all citizens ought to be treated equally under the law, and that should also include criminal proceedings. So if one commits a hate crime, just simply being able to be exempted from prosecution due to citing a religious text, we think is inappropriate. So we think that this is not really going to have any impact on religious belief, but it would strengthen equality rights under Section 15 of the Charter. So we think it would be beneficial. And I'll give you a tangible example, since we've been talking a little bit about LGBT here. Person A calls for violence against male homosexuals. Person B does the same, but invokes Leviticus or passages from Hadith. In our eyes, both ought to be prosecuted equally. So we think it's like a moral principle that ought to be reflected in the criminal code.
So speaking of hate speech, which is exempted from prosecution if it's derived from a religious text, do you think that this constitutes a violation of equality rights?
Is it as the law currently stands?
As it currently stands.
Yes,
correct.
we do.
Okay. Mr. Bennett, would you like to comment on that?
I mean, I would broadly be in agreement with what Mr. Oliver had to say. My concern would be that as Section 319, subsection 3B is right now, I think it would need to be amended to capture that incitement to violence aspect. There are going to be those people, such as myself, who hold different views on questions of life, on questions of marriage, that some might deem to be intellectually violent, right? But I hold those out of genuine belief in my Christian faith. I don't seek to harm anyone by those beliefs. That's the belief that I hold. So I think if you were to do anything with that subsection, I would suggest adding some appropriate text whereby the person in establishing the opinion on a religious subject or an opinion on a belief in a religious text must not incite physical violence against an identifiable group or a member of such a group.
Thank you. Very helpful. Now I'd like to share the remainder of my time with Mr. Virani.
Thank you, Mr. Sassy. So let's just continue on this theme, because I'll confess to you I found it a bit puzzling, Mr. Rosenblood, in terms of your opening submissions about 3193 sub B. One, because the preamble of the Constitution talks about the supremacy of God and the rule of law. Secondly, because it's well known in law that we carve out accommodation or exemptions for religious or conscience beliefs. Most recently, in the one issue that I think all of us will remember for our entire parliamentary careers, medical assistance in dying, where you had a direct conflict between people who felt that, pursuant to their own conscience, they didn't want to have to be compelled to perform a certain type of medical procedure. That was enunciated in the penultimate paragraph of the Cardus decision, since you're citing Supreme Court case law. It's also entrenched in Bill C14 or C16. So I just put that out there as a talking point. You also mentioned, Mr. Rosenblood, that you're cautioning us not to act quickly. And I would actually say to you, if you were listening to the people earlier, there's a real need to act quickly. And I think the need to act quickly is that people are being radicalized to violence online in Canada. That's part of the court record in the Bissonnette sentencing hearing, and around the planet. So I think it is actually incumbent upon us to act quickly. And I was also a bit puzzled by your citation of a dissenting decision in Keegstra, as opposed to citing the unanimous decision of the Supreme Court in more recent jurisprudence, which is Whatcott, where Rothstein, writing for the entire court, upheld Section 13 of the Canadian Human Rights Act as striking that appropriate balance. There's no doubt that balance needs to be struck. So the question I have for you is Section 13 of the CHRA, whose analog was upheld in Whatcott in a unanimous 6-0 decision by the Supreme Court, the right balance? And if it isn't, what's needed? And is what's needed what would effectively be a redundant but perhaps necessary political paragraph, which simply says nothing in the aforementioned passages derogates from the constitutionally held right to freedom of expression held by all individuals in Canada under Section 2B?
Thank you, Mr. Virani. It is because we feel that this issue is important, that the Canadian Secular Alliance feels it is more important that the government act correctly over quickly. Acting quickly may not achieve the goals that we are trying to reach, and that's why we believe that because it's new, it is unfamiliar territory for the vast majority of Canadians and parliamentarians, that we need to consider what needs to be done properly and not simply do something for the sake of doing something. As far as your direct question on the Section 13 of the repealed Section 13 of the Canadian Human Rights Act, it's not something that we feel that the current law strikes a reasonable balance in terms of restrictions on free speech. We feel that existing provisions can be enforced more rigorously and more consistently across Canada, and that the larger problem that we face is not a lack of legislation addressing hatred in all its forms, but a lack of enforcement of existing provisions.
Thank you, Mr. Virani. Thank you, Mr. Rosenblood. Before